Okay, well, it looks like we're going to have a pretty intimate group today, but I'm grateful for those of you who are here, and we should probably start by just going around. I think I know almost everyone, but just start by introducing myself. I'm Brian Stetton. I'm the policy director at the Treatment Advocacy Center, and we try and pull judges together every 4 months, 3 times a year, as one of the stakeholder groups in our AOT learning network, and just feel it's always a valuable thing to have judges talk to each other about how AOT courts are going. And this time we've expanded the pool a little bit and brought in some other attorneys, as well as Dr. Munitz, who you'll meet in a minute, because we want to talk about an issue that I think has a particular interest to judges, but also I think maybe a broader audience, and that is the opportunity to use AOT to alleviate the strain on the criminal justice system, whether there's an opportunity to bring people who are facing pending criminal charges over into AOT courts, rather than deal with them as they have been traditionally, including with mental health court. And I was hoping we could kind of talk about the ins and outs of that, and the prospects and barriers, etc. Let's continue with the introductions before we get into that. Amy, you want to say hi?
Hi, I'm Amy Lutz. I've met most of you. I'm a social worker. I've been with TAC for 2.5 years now, and I cover the clinical aspects of AOT implementation. Betsy?
Good afternoon, everybody. My name is Betsy Johnson, specialist at the Treatment Advocacy.
Okay. Maybe do you want to go around and just ask people to introduce themselves in whatever order you're seeing them?
Yeah, let's start with Mark.
Hi, I'm Mark Munitz. I'm a guest today. Clearly, I'm a psychiatrist, retired a little over a year ago as professor and chair at Northeast Ohio Medical University. Prior to that, spent a lot of years in Summit County, Ohio, the greater Akron area, setting up and helping to support an AOT program, most recently with Judge Stormer. I'm happy to be part of this discussion. Thanks for having me.
Judge Faber.
I'm Robin Faber. I'm the administrative judge for the County Criminal Division in Miami-Dade County, Florida. I first learned about AOT about 4 or 5 years ago, as some of you heard. And I did all of our cases here up until about a year ago when I was named administrative judge. And but I still dabble in it and do a lot with it. And looking forward to hearing what everybody has to say.
Michael Gomez.
Hi, everyone. My name is Michael Gomez. I'm an assistant county attorney assigned to the mental health litigation in El Paso County, Texas. Very nice to meet all of you, and thank you for allowing me to participate in this meeting.
Thanks, Michael.
Judge Parsons.
Hey there, I'm Amy Parsons, the Associate Judge with Harris County Probate Court number 3, and I handle the status conferences with our AOT patients, and we are a new SAMHSA grant recipient, so we're super excited, and it's the best part of my job. So every Thursday when we have our status conferences, it's the best day of the week, so glad to be here.
Daniela Chisholm.
Hi, everybody. Daniela Chisholm over here in El Paso, Texas. I'm the attorney ad litem for the AOT program. I'm very, very new to the program. I just came aboard on January, and along with Judge Parsons, it's also my favorite day of the week is Thursday when we have our status hearings with Judge Strelitz and Michael. I'm here just to listen and learn, and thank you for the invitation.
Judge Stormer.
Sorry, there we go. I'm Eleanor Marsh Stormer, the probate judge in Summit County, Ohio. I've worked with Dr. Munitz, helping to set up an AOT program. He worked on it, I think, in the 90s. So we've had it for a long time and added a judge component. And I used to tell people, which I still tell, it's the most fun you can have with your robe on. Now, I might be stretching that a little bit, but it's pretty close in my opinion.
Judge Kolikoff.
Hi, I'm Jeff Kolikoff. Judge Faber mentioned a few minutes ago that he had done AOT and mental health problem solving until about a year ago. And about a year ago, I became the judge who does AOT and mental health problem solving in Miami-Dade County. So I've learned a lot from Robin and hope to learn a lot from y'all.
Welcome. Judge Park.
Good afternoon. I'm Dixie Park, judge of the Stark County Probate Court. We've had an AOT program for about 4 years, and we're looking to see how we can expand it.
Judge Park, tell us again what county you are from?
Stark County.
Oh,
Ohio.
okay, it's in Ohio. Yep, got it. Thank you.
Canton. Yep. Judge Strelitz.
Hello, I'm Joseph Strelitz. I'm the associate judge for probate court number 1 in El Paso County, Texas, and have been hearing the AOT cases since we started our program. And I agree with Judge Parsons and Daniela. It's the best day of the week.
That's awesome. Judge Lou.
Sorry, I'm late.
It's fine.
We're just glad to see you.
It's good to see everyone. I'm Judge Cynthia Liu from Washoe County, Nevada, so Reno, Nevada, northern part of the state. I've been in leading an AOT court since 2015. I want to say we started with the SAMHSA grant and then became state funded. So it's a pleasure to see everyone. And I also agree with the last statement that AOT really is the best docket that I have. So thank you.
Very nice. And I think that's everyone. So with that, let's kind of launch into our topic today. And I thought to kind of frame it, it would be good for me to start by just presenting a couple of the states that actually have law on this question of whether it's a possibility to bring someone in from who is facing pending criminal charges into an AOT context rather than continue with their prosecution. And there are 3 states that have addressed this legislatively. We think this is actually possible in all 50 for reasons we'll get into. But there are 3 states that have language, and I thought I'd just take a quick look with you at a couple of them to just see the different approaches that are out there. If I could get screen sharing power, Amy, or maybe I have it already. No. Did Amy step away? Apparently Amy stepped away. Okay.
Brian,
No.
I'm texting her now.
No, you
Sorry?
should be good. You should
Oh,
be
I
good.
should be good? Okay. Yes, I am now. Good. Thank you. Okay. So the 3 states, I think we have all states represented that have law on this. They are Texas, Florida, and Nevada. And the approach in Texas is to make it possible for the criminal court judge to actually send the case over to the probate court to be dealt with as an AOT. So if you look at the Texas Code of Criminal Procedure statute, you'd have an analog to it in every state that it makes that says that when someone who is in custody appears to be mentally ill, it needs to be reported to the court. The court has to receive a report based on an evaluation of the person, and then the other information is available as to what should happen next, whether the case can proceed after the trial court receives this expert written assessment. It can do what used to be 4 things, and a couple of years ago this was expanded to add a 5th thing. So the first 4 things are the ones you would expect: resume criminal proceedings against the defendant, halt the proceedings for competency restoration, simply consider the written assessment during the punishment phase, refer the defendant to a specialty court, a mental health court or some kind of a drug court that exists within the criminal system. And then this new 5th option, where it says, if the offense charged does not involve an act, attempt, or threat of serious bodily injury to another person, the court may release the defendant on bail while charges against the defendant remain pending and enter an order transferring the defendant to the appropriate court for AOT. Law goes on to say, if an order is entered under this fifth option, an attorney representing the state shall file an application for AOT in the probate court. And on the motion of an attorney representing the state, if the court determines the defendant has complied with the appropriate court-ordered outpatient treatment, AOT, the court may then, when we come back to criminal court, dismiss the charge pending against the defendant and discharge the defendant. And finally, it says, on the motion of an attorney representing the state, if the court determines the defendant has failed to comply with AOT, the court shall proceed under this chapter or with the trial of the offense. So what this is contemplating under Texas law is basically making AOT work kind of like mental health court, where it's a chance to get your charges dismissed. We'll see how that works out, and if the person stays very compliant with the AOT and the criminal court gets a good report back from how things went in the probate court, that could lead to dismissal of charges. If the person does not stay engaged and do what we hope they will, it could lead to the charges coming back. So it means you're going to have AOT with a whole lot more riding on it, a whole lot more at stake than you normally would in a purely civil context.
Brian, may I ask a question? That it doesn't matter if it's a felony as opposed to a misdemeanor, either one?
So as long as the crime does not involve threat of serious bodily injury to another person, that's correct. It doesn't.
So it could be a felony. Okay.
Yeah, you could have a felony, non-violent felony, yes. So let's contrast that with the Nevada law, which I think is kind of like the Florida approach, which is that they're contemplating AOT actually happening in the criminal court. So if you just look at the Nevada statute on the filing of an AOT petition and how that process normally works, there is another section that was added a couple of years ago that says a proceeding for the involuntary court-ordered admission of a person who is a defendant in a criminal proceeding in the district court to a program of community-based or outpatient services may be commenced by the district court on its own motion or by motion of the defendant or the district attorney if the defendant has been examined for competency, the defendant has been found not eligible for commitment for competency restoration, and finally, thankfully, that the division makes a clinical determination, that's the division of basically the Department of Mental Health, makes a clinical determination that the placement of in a program of AOT is appropriate. So I don't know how much this is happening, if at all. Judge Liu can probably illuminate that for us, but what this is contemplating is actually something very similar to what our judges in Miami are doing, which is AOT actually happening in the criminal court, where a court that would normally have criminal jurisdiction actually has power to do AOT. And if the Florida law, which I don't have up today, I can just stop sharing my screen here. The Florida law is similar to Nevada's in that the general AOT law, in defining the court that has power to order AOT, that definition includes a criminal court with jurisdiction over a misdemeanor matter. So that makes, again, it possible to do AOT right in criminal court without having it transferred to the probate court that would normally hear those matters. So Judge Faber, do you want to maybe or speak a little bit about how that works?
Well, the way it works in Florida, because we don't have a statute that says that it can be transferred over to the probate court and handled under their auspices.
Right.
What we have is a statute that says AOT can be ordered by either the probate court or the county court judge with criminal jurisdiction, which is what I am and how we brought AOT in. And so when that law was changed to include us, that's when we started figuring out a way, okay, how can we make this happen? And that's, of course, when I met some of our other judges here when we went to Washington. And we've been doing it now for about 4 years. We've been doing this and actively for the last 3. And we've had pretty good success with it. What we do is we try to identify people who would be eligible under the statute, having enough documentation to support that they've been hospitalized 3 or more times within the last 3 years and all those other requirements that are needed under our statute. And once they're identified, then the hospital who is involved in that identification process at the jail sends a request. They file an affidavit requesting us to send them to the hospital for a specific evaluation. And that's exactly what we do. We send them to the hospital. So the hospital is actually the ones identifying particular defendants that are appropriate. And then they make the final decision in terms of they want this treatment for this individual. I might say, for example, I think, John Doe is appropriate or seems to be qualified, but they're the ones who actually say, hey, we've got the documentation to support it. And then they review this person specifically to make sure it's appropriate, because not everybody that you send over to the hospital is really appropriate for this sort of treatment. And so I said from the very beginning, I don't think it's my decision. I'm not expert enough to say it's right for this guy. And we have really been working, looking for the deep end clients. We've specifically tried to target the really deep end person where their life is being threatened by their lack of treatment and not following through on treatment recommendations.
And
I think that's what it was intended for.
Yeah, understood. And I know you all have a very celebrated mental health court as well.
Well, that allowed us to bootstrap this,
right?
Because it was already set up. We had the procedures in place to send people to the hospital if they were in crisis, for example, and things like that. We already had the mechanisms to bootstrap for this AOT review.
Yeah. So I think it would be helpful for everyone to understand what determines whether a particular individual winds up in the mental health court or the AOT program, and how the two interact with each other, if at all. Maybe that's what Carla Crawford would want to take.
Jeff, you want to take that one?
Sure. What all of our judges who handle really our first appearance hearings are looking to identify individuals who have serious mental illnesses. And when they do that, they can make those make a referral to the mental health diversion team. And then also, a lot of it is self-reporting, because folks who report when they're booked into custody that they have a qualifying diagnosis, that starts the ball rolling, because oftentimes they're medicated in the jail. And if they're compliant with their medication and compliant and want to participate in a program, then they would go to the mental health diversion program. If they have a qualifying diagnosis but are not taking medication and won't consent, or and they appear to be a danger as well, that's when AOT gets involved. The hospital gets involved, and they get an evaluation to AOT. The mechanism, actually, my Wednesdays are my mental health day, so I get both sets. I have a morning calendar for in custody folks, an AOT calendar at noon, and then an afternoon calendar for out of custody folks. And I also sprinkle in incompetency issues in there as well. So my Wednesdays
are a busy guy.
So but it really depends upon the identification. The other thing is that we have the public defenders are in tune with this as well, and they know there's out of custody referrals, but for various reasons, out of custody referrals for AOT are slim, just because those folks, the folks who we identify for AOT are the ones who are in crisis already, so they need to be transported to the hospital, and they would typically not be out of custody.
So am I understanding you right? Then it's basically people who decline the voluntary offer to participate in mental health court, who then can wind up in AOT?
Yes.
Sure.
Yes, absolutely. Right. And there are some folks who are not even identified, who you see something that occurs, some outburst in court or in the jail in custody, that they probably have some issue, even though it wasn't previously identified. And then the process, we prefer to use our mental health diversion court as opposed to AOT if we can get buy-in from them and voluntariness. If that doesn't happen, then we look to AOT.
Right. So you're really dealing with, I would imagine, a more difficult, challenging population in the AOT court than the mental health court is.
Yes.
That's internally motivated.
Exactly. Many are much more deep end. And
Right,
we have our
right.
frequent flyers. We know them by name. They come in as you guys are, I'm sure, aware of in your jurisdictions. So you have a pretty good idea who you're dealing with.
And what happens to the criminal charge? It's basically put on ice for the
They're
time?
put on ice.
Yeah.
As far as I'm concerned, that person is, there's a provision under Florida law where speedies can be told. I use it and I told speedies. I basically put the criminal case on hold, as that's what we do. And then we deal with the AOT case. And once they complete their treatment of AOT, then we revive the criminal case, but we put them into the JDP, our regular mental health court, to kind of follow through and make sure they're following through on that treatment. Because by the time they graduate AOT, now they're willing to take their medications. They're willing to, do the things that you are asking them to. And our state attorney has been very good. I mean, honestly, they work out these cases, they dismiss charges, they do a lot of things. I got their buy-in from the very beginning as we went through this process, but we're very fortunate that we have a state attorney as well as a public defender that really is interested in treatment and alleviating the root causes of this criminality that we have to deal with in the criminal courts.
Right. And it's interesting because it sounds like the person will not have this sense of, if I screw up here, I'm going to wind up being prosecuted. Whereas if I do well, my charge is going to be dismissed, because the charge isn't going to be dismissed in either case, right? I mean, it may impact how the charges are handled ultimately, but the criminal charge will come back upon graduation.
The criminal charge will be revived, but often it can be, the state attorney will agree to dismiss it ultimately. There's certain charges with victims and things like that where that's a little bit dicier to say they'll dismiss the case, but they do a sweetheart deal. They don't keep people in jail. They don't reincarcerate them.
Gotcha. Interesting. So Judge Liu, to your knowledge, is there anywhere in Nevada where any criminal court is actually using its authority to do AOTs themselves?
So the process in my county has been similar to Florida, where the criminal court will just order the person into AOT upon acceptance and then actually transfer oversight to my court.
That's very
right. So they treat it really similar to a specialty court process. And I think that just because the AOT program's heard in my court, it's just easier for everyone to have it go through one, place.
That's
Judge
really
Liu,
interesting.
I have a quick question for Judge Liu. So you take over jurisdiction of that case and you handle the AOT treatment side. When that is completed, or at the end of that, is the case then sent back to the criminal side?
It can be sent back to the criminal court for any final disposition. And so, but we're all on the same bench, so we easily can communicate, which makes it easier. I also have a lot of cases of people who are on probation, and as a condition of their probation, they're in the AOT program, but again, still need to be accepted through the civil process. So we almost just work hand in hand in that aspect.
Yeah, it makes sense. I mean, there's nothing in the law that says that that's what's going to happen, but in a county like yours where there is a civil AOT program, I would imagine most criminal judges would just rather do it that way, rather than hang on to it. Of course, they don't have that.
Is there any kind of a disconnect? I'm sorry.
Yeah, go ahead.
Sorry.
I was just going to
Judge Stormer, nice to see you.
Hi, Judge Liu. Nice to see you too. So for the people who are doing this, do you have any kind of disconnect between we only right now take people who are civilly committed. We have resisted people on probation and parole as well. But when you talk to them and you can only order hospitalization, I mean, do you mention the fact that they can be sent to jail or prison if you send them back? Or, I mean, does that cause any problems with your other people who can't be sent to jail or prison?
Not really. I don't think it confuses anyone if that's what you're trying to say. I think the individuals just know that they may have unique circumstances, and yes, they know. I mean, we've had to contact probation officers who actually have helped us facilitate getting our people kind of back on track. So we've, worked closely with PMP even before. criminal courts were, actually transferring people to us. So it hasn't caused any confusion. I think they just know they have an additional issue looming over their heads.
Mhm.
Have there been times where those transfers just haven't, in your view, been appropriate, where, the criminal court had in mind this was someone good for AOT, but you just didn't see it that way when you brought the case?
We've only done it a few times thus far, but usually they go through the AOT acceptance process. So that's why we actually haven't had an issue with that either, thankfully. So we haven't had any judges just order it without them getting accepted in the AOT at this point. So.
Yeah. Okay. So let's ask our two Texas judges, who I know are presiding over very new AOT programs. It's probably unlikely this has happened yet, but have you had any experience with cases coming over under the Texas procedure we looked at?
So for Harris County, we haven't yet, but only because, as Judge Stormer said, we've been a little resistant to that because we wanted to get our feet sound on what we were even doing to begin with, because we anticipated or anticipate like a fire hose effect of those types of cases. But what's interesting, and I was, Judge Liu and the other judges, so what on our statute, the way it reads, in the way I understand it, the case is dismissed and then transferred to civil commitment. It seems interesting on y'all's particular laws where you don't have the dismissal of the charges, right? And so they know that, to me, that would be an extra incentive to have their cooperation, knowing that, oh, it wasn't dismissed, you just have to do this program in order to get it potentially dismissed, which I tend to think would be more helpful than those that they already know they've been dismissed and they're just here.
Yeah.
So I can see it working, either way, but can imagine that definitely helps incentivize the cooperation.
Yeah, that's an interesting, it's a discussion point I want to get into further, but I will say your Texas law actually contemplates exactly that the charges would not be dismissed, that they would be held in abeyance.
Yeah.
So, working under the current law, that's what would happen.
Yeah. So what's interesting is we actually had a case yesterday. I got a call from a judge in a different county. She was a visiting judge and had this exact issue. She was visiting judge and there was a person who had a scuffle with somebody and got some, minor charges pending in the tiny little town somewhere. I don't even remember. Oh, it was somewhere in the hill country. And long story short, they wanted to they had a competency hearing and found that he was not likely to regain competency. So she was then going to get into the civil commitment part of it. And she called us to say, hey, do you guys have a form for this? Because I don't have any. And I was just, and so when we got into the weeds with her, I thought, we've just found out that the person now lives in Harris County and really had always lived in Harris County. It's just that particular act occurred in the other county. And so I said, well, I would love to give you a form, but I wonder if maybe I'll do you better and you just send us the whole case, because, the civil commitment part sounds like it needs to happen here. And we're sort of working through that. But this is really the exact thing you're talking about, that potential person, she was wanting, I said, so you're wanting to put him into outpatient commitment? And she said, yes, because that would make the prosecutor in this little county feel better that some other court is kind of have, a little oversight over him. So,
yeah.
Judge Cox, I think is a little hesitant right now because of, again, the fire hose effect, but I can see that coming.
Absolutely. And I'm not sure you could actually stop the fire hose effect. I mean, if criminal court judges exercise the authority they have to simply send the cases over to you, the fact that even if you don't feel ready for them, I think you'd have to take them just like any other petition that got filed.
Well, and I think that was part of the hesitation to say, okay, wait, let's just handle with what we can control at the moment. So.
Yeah, understandable. Judge Strelitz, has this come up at all in El Paso yet?
I don't think we've had any cases referred to us from any of the criminal courts. What has happened, I think, and Daniela or Michael, correct me if I'm wrong, is that we have some patients who are traveling down both tracks. And Daniela is working with, in some cases, the defense attorney, and I think in some cases, the prosecutor, to let them know that the particular patient is in the AOT program and to allow them to use that to maybe dismiss the charges once the patient successfully completes the program. But we haven't had anybody refer us directly. I'm hoping that we can use these cases that we have as examples to the criminal courts that this is a process that works. So we'll see what happens.
Yeah. Yeah. One thing I wonder about in the states that keep this in criminal court, I guess it would only be Florida, even though that's possible in Nevada, it's not actually happening. But there's, I guess, a question for our two Miami judges. What authority would you have as a criminal court judge to have the person ordered for pickup? The normal remedy that's associated with AOT, if a person is not compliant and you've made good faith efforts to get them to comply and it's just not working and you have concern the person now may need to have their order modified, what that typically leads to is an opportunity for the judge to have the person brought in for a short-term hold for an evaluation. But a criminal court judge does not normally have that authority to make that order, right? So how does that work practically?
Well, we do have the authority under Florida law because we're authorized to compel AOT and all the accoutrements come with it.
Yeah,
so that's what we do. Now, we don't use the jail as a holding facility. As far as I'm concerned, someone who's out of compliance, for example, I want to go to the hospital. I want to get them stabilized and then right back into treatment. Now, sometimes it's unavoidable. Somebody walks away from treatment. We don't know where they're at. I have to issue a warrant. My case is alive. It's kind of in hibernation, my criminal case.
Yeah.
So if I have to use it as a vehicle to get that person, I will use it. But we send them right back to the hospital and right back into treatment. We try to keep them out of jail as much as possible because jail is not treatment.
Right.
Jail is holding, nothing more, nothing less. And a bad environment to hold. I'd rather hold them in a crisis center. So.
Yeah, that's great to hear. And it sounds like you're basically operating a familiar AOT court that we would recognize.
No. And Jeff's been great in handling all of it. So.
Mm-hmm. So turning then to the practical application of this model for states that don't have law on it, such as Ohio. I don't think we have any other represented in our group today, but that this is the case in every other state that has an AOT law where there's no law on this. There's really not going to be an opportunity, certainly for a criminal court judge to do it themselves, or for, as in Texas, this kind of formal procedure where you actually have the case put on hold so that this can take place and toll the statutes governing speedy trial. But we at TAC feel strongly, and I know this is something that Mark is on board with as well, that there is a real opportunity to make greater use of AOT for people who are stuck in competency restoration limbo. And from our point of view, that probably would have to involve dismissing the charge so that, little extra edge that Judge Parsons was talking about, giving the person a little more motivation, might be taken away there. Where you have a mental health court operating on the criminal side, there maybe isn't much reason to send people over to AOT if people are willing to do mental health court. But of course, that requires that their charges be viable before that could even happen. I would kind of like to get the discussion into the possibility of everywhere, right, having this application of AOT as a tool for people who can't go to mental health court because they can't be restored to competency within the statutory time limit. But they do meet AOT criteria. Mark, I know this is something you've looked at a little bit. Do you want to share your thoughts on the potential to make that happen in Ohio?
Well, this reality that throughout the country, state hospital beds in particular are being increasingly occupied by people there for competency restoration, which is crowding out the availability of state hospital beds. And there's a cascading effect on the rest of the treatment system. So there's less access for people who are just sick and need treatment. And the end result of the competency restoration process in many, many cases, particularly for the nonviolent misdemeanor kind of cases, is that ultimately the person's found not restorable, the charges are dismissed or time served, et cetera, and the person's not connected to treatment and then goes through the cycle again and again. So I mean, I think we've all heard those stories. And when I heard the judge describe the deep end cases, I think if I understood right, Judge, you were talking about people who were really quite ill, who needed to be in the hospital. They're not well enough to be restored to competency, for example, in outpatient settings. So it seemed to me for some time, and no one has convinced me that I'm wrong about this, that there are a bunch of people who are getting in trouble, oftentimes repeatedly, really with trouble with the law, largely as a result of their mental illness, being symptomatic and untreated. Many of whom probably meet the prototype of the AOT patient, the person who's got a serious mental illness, responds to treatment acutely, but doesn't think they're ill and therefore discontinues the treatment, goes through that cycle. And so, so the hypothesis, and Judge Stormer has worked on this in Summit County, is that there are a group of people who end up in jail, who are sick enough to meet civil commitment criteria to need inpatient hospitalization, and that it would serve them and the community best if, instead of waiting for a competency assessment, which is a long wait in the jail, and then typically a fairly long stay relative to civil commitment, acute hospital admissions, long stay in hospital, to screen them quickly, identify those individuals, and with prosecutors okay, which is, I think, is a huge challenge in many communities, and in collaboration with the treatment system, having that person essentially charges dismissed without prejudice, and the person is then civilly committed to the hospital with the idea that the hospitalization will be brief, because they almost all are, and they would come out of hospital on AOT. So that the criminal court and all of the players there could be assured that the person is under supervision and getting the treatment they need. The probate court is assuring that through the AOT process, and the person's getting the treatment that they need and hopefully staying out of trouble. So that's kind of the theory. It's been difficult to pull this off. I've been retired for 15 months, so I need Judge Stormer to update me as to whether any of this is happening in Summit County. But there's so many pieces and parts for it to happen that it makes it difficult. But the yield, I think, is potentially so great that it would be worth figuring out how to do this. But everyone would have to be on the same page in the community if you don't have a statute kind of laying.
We might have a statute. So that's the update. I know they were working on trying to get a quote unquote competency restoration statute in place. It's passed the Senate, but it is not nearly as comprehensive as what the other judges are describing. And I posted a question because I don't mind taking the disorderly conduct, the guy who's camped out at the bus station because he doesn't really have a place to go, and they arrest him for criminal trespass and he really belongs in AOT court. I think he's a perfect candidate. But what we get from criminal side is they're trying to, and I say use the word dump, and I mean it, dump people with profound substance abuse issues. I mean, these are meth heads who also are mentally ill. We have no ability in my court to keep them in treatment when they get here. I mean, if they don't want to do treatment, if there's no criminal hold, we just say, well, we're going to take you to the hospital, and, they just walk out of the hospital. So the lower level misdemeanors, we'd love to have them. And if that statute passes, we may. It would certainly allow us to save hospital bed space, which in our state is very scarce. It may be different in the different states, but we have real trouble getting people in who need to be in. So it would give us more hospital beds. But there is a statute, it's passed the Senate. I don't know what's going to happen in the South. Betsy may know what happens going to happen in the South, or it's not the South, in the House. Sorry, they're south of me in the House in Columbus. Sorry.
You want to give an update on that, Betsy?
Sure, yeah, it's very likely it's going to pass and pass soon. What it does, one of the things it does that it allows the criminal court and the civil court to share information. There is a belief that unless they weren't supposed to be sharing information across the two systems, and so they felt the need to have to spell it out in the statute. That's one of the reasons for the change. And then otherwise, I think it just clarifies that this process can happen. There are lots of jurisdictions that are already doing this informally around Ohio, but we don't have any, we're not able to collect data to find out if they're having, success or not.
Yeah, and I think that's really the key point. In Ohio and all the other states that don't have any law on this currently, I don't see any reason why you need legislation to do the thing that Mark is describing, where the charges get dismissed. It's always in a prosecutor's discretion to dismiss charges.
You got to get a prosecutor willing to do that.
Well, that's up here. And that's the question. I think it's, worth noting that we would be talking about dismissal without prejudice so that those charges could ultimately be brought back at some point. It's not the person is, scot-free. I wouldn't imagine they would be brought back if the person successfully completes AOT. I wouldn't imagine the prosecutor would be interested in bringing them back unless they reoffend. Then you might pile on with the old charge. But this potentially in our efforts, and this is something TAC is strongly interested in making a reality and finding locations to try it. But the greatest barrier I would anticipate is going to be the DAs, and are they going to be willing to dismiss charges? I think the way you sell it is, look, we're talking about cases where you're ultimately going to wind up dismissing without prejudice anyway, because these are the folks who are likely not restorable within the time period that you have to restore them. So rather than go through the charade of, the kind of pointless exercise, I should say, of futile competency restoration attempts, ultimately leading to dismissal in a couple of months, and the person might have spent a lot of that time in jail and gotten worse. Why don't we dismiss them up front, get them the treatment they need, and make sure that when they do get back into the community, they've got the support and the monitoring to succeed. So
Ryan, one of the reasons we in Florida, and it's different from other states, there's a difference between compelling competency restoration when someone is charged with a felony as opposed to being charged with a misdemeanor. In Florida, if you're charged with a felony, a judge can compel treatment, inpatient or outpatient, depending on what's recommended for that given individual. They have all the competency restoration programs and all that. If you're charged with a misdemeanor under Florida law, you can't compel it. You can't do anything if you find that person is not competent to proceed to trial. So that's a real dilemma for us, because I have that person, but there's not a darn thing I can do with it. In fact, we prefer not to find somebody incompetent on a misdemeanor. We prefer to get them into treatment and use AOT where we can, because that's your best avenue to get the result.
Right. And that's why it's nice that you have that tool, but not everyone does. Most people don't. Interesting.
That's consistent with what we've talked about here, that in Ohio, that the goal is to get people treatment and not even raise the issue of competency, because once the issue is raised, it slows everything down. Even if you could do something, it's keeping people in jail longer than they need to be there. And if they get to the hospital, it's keeping them there longer than they need to be there, ideally, and really clogging the system and not getting them the help that they need in the best way.
Yeah. Anyone have any thoughts or reaction to the prospects of getting DAs, prosecutors to buy into this model? Do they see it as a tough sell? Daniela, you probably have experience with the DA's office.
Well, I wanted to add, Brian, we have a new DA coming into El Paso, which kind of just sparked a little bit of an opportunity in my mind. She was a criminal defense attorney for some years, and I worked alongside her, and kind of thought maybe this is something to approach with her, since she's coming in and she's pretty much reorganizing the structure of how everything was done. I don't think previously this would have been something that would have been entertained, but I do think there might be an opening with this particular DA to at least sit down and have a conversation about this, because over in El Paso, we're a bit behind we don't have a mental health court, criminal mental health court to work with even. So I think this might be a way in with this new DA to talk with her and get something like this started.
Can I make a suggestion in that
Yeah,
regard?
please.
Because my experience has been, as much as I try to play up the morality card of how it's the right thing to do, what I find is most responsive is the cost savings. And
Okay,
it's a
absolutely.
huge cost savings. If you do the calculations to find out how much they're spending in this COMC restoration stuff and all this other stuff without addressing the mental health aspect, which is far cheaper to deal with. And that's the big selling point. And we've used that here in South Florida, and we've got buy-ins not only from our state attorney, our police chiefs have bought in. The cost savings to them is dramatic. So all the different justice partners that are part of this criminal justice system have seen huge cost savings from what we've done. And that's the selling point that they really buy into. So
Okay.
just a suggestion.
Great point. And that's really great to hear too, Danielle. I mean, we have a lot of these more progressive DAs that are coming into office around the country. So this may create some opportunities, and El Paso could become a pioneer here and attract a lot of attention for doing it. So we'd love to work with you to make that happen. You know, it's interesting though, because you guys are in Texas, under the legal procedure that you have available under the statute we looked at, they could do it without dismissing the charges, unlike other places where we would have to dismiss the charges to make this work. We wouldn't have to do it that way in Texas. So I wonder what your thoughts are, you know, our other folks from El Paso think about which way is the way to go. Do we want to sell this to the DA as let's put the charges on hold and maybe use the potential of bringing the charge back as an extra bit of incentive, as Judge Parsons said, for getting the person to stay engaged? Or do we think it's actually a better idea to do what we could do elsewhere and dismiss the charge up front? What do you guys think?
Well,
Go ahead, Daniela.
well, I think the putting on hold is a little bit, maybe a little easier to sell. I could see the incentive. We kind of can keep, you know, that open and I don't want to say over the person's head, but just available, you know, so there's coverage all around the person while they're attending the program. So I tend to think that may be the better route. I don't know what you think, Judge.
Well, the only thing that jumps into my mind about that is, I think that's a wonderful thing to have, is either you participate in the program or you go back into the criminal side and maybe you get to go to jail or you get to pay a fine. The problem that I see there, maybe with some of the courts, is, you know, everything is in Texas is starting to be about numbers. How many cases can you dispose of and how fast can you do it? And so if some of the criminal courts see that this is a method for disposing of their cases, I don't know if they're going to be real excited about holding on to the case for as long as I'd like them to, so that we can get somebody to really get through the program and get a benefit. Of course, I could just be guessing there. Just something that.
Yeah, just having it lingering on their pile is an extended period could be a disincentive. Yeah.
That's why we have invented stays, Brian. You just stay it. It doesn't count until you unstay it again.
Say again, Judge Stromer, I missed that.
You stay it. You just stay the case. So it doesn't show up on the prosecutors. They want to show, hey, 1,000 people charged, 1,000 people found guilty. You just stay it. So that should be a compromise for your prosecutor, because they can just shift him over to another line item, I guess would be the way to say it. Don't let them talk you out of it, in other words, for that reason.
Brian, have you seen other Texas counties do this? Have you actually, do you know any Texas counties?
No, you guys would be El Paso, if you were to take this on, or Houston would take this on, you guys would be pioneers.
I mean, logistically speaking, at least in El Paso, we have So the DAs handles the criminal side of things, but then the county attorneys handles the civil commitment. So I don't know how it would work logistically. I mean, first, just transferring the case over to the probate court, does it keep the criminal case number? Or are we opening a new case? And then who is that? Who would be the state's attorney under the 1622 that actually files the application? Would it be the DAs? Or would it be
So the statute says the DA, let me just take another quick look at it. I believe it says
the
the
attorney
DA
representing the state? Doesn't it say the attorney representing the state?
Let's take a quick
Yeah.
look. It says, if an order is entered under subsection 5, the attorney representing the state shall file the application.
So that could arguably be
either, right?
Either, yeah.
Yeah.
I think it would probably be best to have the county attorney do it, but I see, is it Judge Prasher?
Yeah, Judge Prasher from Austin has joined us.
Right. I'm wondering what he has encountered with respect to any of this.
Well, things are kind of chaotic here because we have a new county attorney who has the best of intentions, lovely person. But she came in, riding her white horse saying, well, we're not going to prosecute criminal trespasses at all. We're not going to prosecute any of the things that traditionally got people into the mental health system via the jail. And the owners, managers of places like Stop and Go that don't particularly appreciate people standing in front of their door screaming at customers are really unhappy about this. And now she's trying to sort of rethink it. We do a lot of dismissive transfers. The problem is they usually come via the competency restoration mill, and I have not been able to talk them out of getting everyone shrunk that this issue is raised with, because once you get them shrunk, once someone files the motion, you've got to go through it. Once the first piece of paper is on file suggesting that someone is incompetent, the court has an absolute obligation to determine whether they're competent, period. And we're still stuck there, notwithstanding all the wonderful talks that we've had Judge Leifman give about avoiding the competency restoration trap altogether. I think this is something that's going to have to be dealt with legislatively. Not in this session because it's too late. In Texas's legislature only meets every 2 years for 145 days. So this is something that I think we're going to want to take up next time, Brian.
Yeah. So Judge Prasher, I know you joined after I put on the screen the Texas Code of Criminal Procedure section 1622 that attempts to address this possibility. That when a person is being considered for competency restoration, there is this new fifth option to farm the case out to the probate court for AOT instead. Do you feel like that statute doesn't get the job done?
Absolutely not.
Yeah, why?
Well, first of all, I think it's a lack of awareness. That's the first thing. Second, you still need to have certificates of medical examination. Some doctors got to get them, and that usually happens in the jail. And we only have one psychiatrist in a very big jail, to do all the work. And, he's busy all day long prescribing medicine and that sort of thing. So it hasn't really shown up as an option yet.
Okay.
It's interesting. I will say that, when we've had in the past transfers for civil commitment from the jail, not just outpatient, but just commitment in general, they have slowed down significantly. Our mental health administrator says that basically the jails have just seemed to stop sending them. We don't really know why. Maybe for the same reason Judge Prasher was talking about, but they for a few years they came, pretty regularly, but now it's kind of a rare bird. So.
Yeah, I guess I still am struggling with what isn't workable about the process. I mean, why, if we can get the DA and the criminal courts on board in, say, El Paso County, is there anything under the current law that would not allow this to work the way the law contemplates? I think it could work.
Well, we also have a new DA, and the new DA is kind of like the county attorney. This is, a gentleman who also never prosecuted a case.
Right. Super
And
aggressive, promising huge reforms, right? The way
yeah, and this might be one place to usefully tackle it. Thanks for raising that. That's a good idea. We may have an opening now.
Yeah. One thing I wonder or worry about a little bit, I wonder what other people's thoughts are on this, is if you do go the route as the Texas law contemplates, where the charge is just on hold and you still have that little bit extra leverage with the person, does that change the dynamics of how AOT operates in any way that is troubling? I mean, I wonder whether it makes your AOT clients who have criminal charges pending somehow different in the way you deal with them as a court than the people who don't, because you are, you really have teeth in those cases. You have a real threat of something bad that could happen if someone doesn't comply. Whereas normally with AOT, we're relying so much more on, motivation, trying to develop internal motivation within the person, and have them feel cared about as
Brian, I don't like that idea at all. I mean, I was a chief prosecutor in the Harris County DA's office back in the death penalty days.
Yeah.
And I can tell you the criminal justice system for me now needs to be as far away from this program as possible. We had a well-meaning probation officer, criminal probation officer, that wanted to be part of our AOT meetings and to be kept in the loop with all this stuff. And I said, no, they've got another universe that they have to answer to. And a probation officer, for example, has to be responsive to his judge and to the prosecutor and to that side of it. And, I see our role as just helping people, not also holding the dagger out there. Oh, by the way, if you don't play ball, this is what happens to you. I'd like to be able to tell them, I'm not going to do anything bad to you. I'm just here to help you. And that changes the dynamic and puts me in a position of doing something bad to them. And to me, poisons the idea.
That's a really good expression of what I was getting at. So thank you for that. So it sounds like your preference would be, if we were to do this in Travis County, would be to get the DA to buy into the idea of dismissing the charge up front.
Yeah, which I don't think they would necessarily be loath to do. And I just made myself a note about who to call next.
Judge Prashen?
Yeah.
It's interesting. One of the things that we do here in Dade County is we don't use probation officers at all in our AOT program. We use peers to help with our clients, and we use case managers from the mental health field. We don't use anything. We try to separate the two. So even though there is an existing criminal case, by how we do things around here, the normal people in charge are not involved with this person that has been ordered into AOT. And we do try very hard to keep that segregated so we don't have that problem. And so that I can speak to them as, with my hat as an AOT judge, rather than as my hat as a criminal court judge.
Yeah.
And so, but I can certainly understand the dilemma you've got.
Thanks.
Whatever it's worth.
Yeah.
Well, that's the only way we can do it, is to separate.
Right.
Yeah.
But you have a particular ability to maintain control over that because you are both judges, right? You are the AOT judge and also
right.
judge.
It's a unique situation that we're working
right.
with.
Exactly. Whereas if we tried this anywhere else where it's happening in a different court, there is, I think, this real concern that you don't have full control over what happens next. The person isn't compliant.
Well, do you ever have a situation then where you have the separate, we are separate. So you know, you have someone who tests dirty repeatedly. I mean, these are the people that I'm most worried about, not the people peeing in public or, you know, yelling at the bus station, because that we're good at. But the people that they keep trying to send us have multiple problems. Many of them are violent, which is also an issue, but most of them are substance abusers. And I know Judge Liu has responded to me and, you know, told me what they do, but what do you do if they repeatedly test dirty and you just go, hey, don't do that anymore. I'm your friend and pal. And that's why, you know, you can't serve two masters to me. I can do what I can do. If they continue to use, my expectation is at some point they're going to be arrested for drug use, which has nothing to do with me. And then they're going to be dealt with in that fashion. So I'm very curious, judges who've been doing this, how you handle, you know, that side of it. Judge Liu apparently is getting great compliance by putting people into a treatment center. I have done that a couple times by begging the criminal justice system to take my person. We have one residential treatment center for people who are both mentally ill and profound substance abusers. And every single time they're there for 3 days and they walk away. They just, I haven't been able to keep anybody anywhere. And so any tips or tricks, I would love it, because I think we're going to get more of these people. But that's who they try and send us. Are these people with multiple issues, and you know they say, hey, fix them, you know, get them on their medicine. It's like, well, that's just, you know, the tiniest part. We're good with medicine, housing, etc. We're not good with substance abuse and violence issues. You know, huge PTSD issues piled on top of them, and we're just not good at it. But I know you all are. So if somebody could help me, I'd appreciate it.
And Judge Liu, if you wouldn't mind just saying out loud what you put in the chat box in answer to that.
So we've had participants willing to go to residential treatment programs when they keep using. We've had them be tested. We have them have frequent hearings. We, you know, have their treatment as part of their, or their substance abuse treatment as part of their treatment plan. So we order them to do that. But really it's a repeated discussion and the encouragement. And Judge Stormer, I have to say, I had one person where eventually he landed in jail, you know, and then when he got out of jail and came back to his AOT review hearing, you know, we had a discussion about, so how was jail? You know, did you enjoy jail? You know, did you get the connection with the substance? I mean, so sometimes that's all the whole motivational discussion with them, to say, well, if you hated jail, maybe you should think about what got you to jail and let's try to work on this together. Sometimes it got to that point where, you know, you have to kind of wait till they hit that rock bottom, and then you kind of swoop in and say, okay, you're at your rock bottom. Where do we go from here together? Right? What would help you get there together? What can we do to help you with that? But you're not going to get them all, right? But maybe the ones you can get to, you know, is good enough. So it's just a lot more work, I think, for the judge and the staff. I mean, you are definitely going to feel like you're working harder than the participant at those points, but that's when they need you the most, right? So, and I know, Judge Stormer, you're tenacious and you're wonderful, and you'll keep doing that. You'll give them the help, even if they don't want it. So, you know, you can do it.
Anyone else want to speak to that issue? Oh. Okay. You know, what I worry about, though, is where you're doing this in a context where the person's going to go back to another court, where you don't have as full control over ultimately what happens to the person, because another judge, a criminal court judge, as under the Texas procedure, is going to have to make a determination, not you, but them, make a determination of whether the person has, quote, successfully complied with the AOT in determining whether to dismiss or bring back their charges. That could get messy and bring in some of the things that I think Judge Krashner is worried about. What does it even mean to have successfully completed the AOT? We all know it's par for the course that people are going to have bumps in the road while they're going through this, and to look at to get to the point where a person's graduated from AOT. And by the way, what happens if you want to renew the AOT? You know, normally you have the opportunity to keep it going beyond the initial period if you think the person needs more time to really fully incorporate those habits of treatment engagement to where they're going to be able to do it by themselves. It doesn't mean they failed, just means you think they need a little more time. Does that mean the criminal case is going to stay on hold for potentially a couple of years? But at whatever point we complete that AOT, having a criminal court judge making a decision that the person has been, quote, successful or not seems potentially problematic to me. It's the problem you could avoid by just dismissing the charge. Anyone have thoughts on that? Agree, disagree? Yeah, Judge Anderson, who's also
Well,
George Slate from Nevada County, California. Thanks you made it. Glad you made it.
Thanks. It occurs to me that most of the cases we're talking about where the AOT might be a solution to the competency question is going to be on misdemeanors. Serious felony cases, they're going to go by standard competency, and if incompetent, sent off to a state mental hospital whenever an opening occurs. But we're talking mostly about misdemeanors. It definitely is in the best interest to dismiss the case and let them go through the AOT program.
Yeah.
The problem we had in California is the program's only for 6 months by operation of law. We extend often, but the selling point to a DA is limited because of the 6-month limit. But also the burden of trying to process a mental health case. If we can get a diagnosis of SMI, then I think our behavioral health is going to be on board to allowing someone who's facing a possible competency hearing in criminal court to be deferred over to AOT instead and get out of the criminal system. But that's bolstered now in California because we have that new mental health diversion law, which allows any case to be diverted, misdemeanor or felony.
Does that reference AOT specifically?
Not at all.
Yeah, okay.
Doesn't even mention it.
Right. As I thought.
Okay, so we actually had a case recently that was like in reverse of what we're talking about. So we've had somebody who's been in the AOT program for several months, and she was recently arrested. It was assault of an officer, I think is what the charge was for. So she's been in the jail. And so Judge Cox was like, well, she's been there for several weeks. Like, what's going on? Is she going to get out? You know, and the prosecutor was not interested in dismissing charges. And then they sort of referred her for competency restoration. But in the meantime, we had the docs, the outside doc, AOT doc, and the inside jail doc have a doc to doc. And they both agreed that based on the charges and where her current state was, that they thought that she should be dismissed from AOT, meaning she's no longer appropriate for all these other reasons while she's in jail dealing with all of her criminal issues. So that happened just recently.
Yeah, that's probably a familiar story to others as well. So I'm wondering whether this discussion about the pros and cons of dismissing charges versus putting them in abeyance, as the Texas law allows, has maybe changed anyone's thinking or minds or about how we should proceed. I guess our three participants from El Paso, I'm wondering where you are landing now on this question. Maybe it's just gotten muddier for you. But do you think we could sell this as a potential dismiss the charge program or?
Well, I think a lot of good information was brought up from the judges across the board as far as dismissing the case up front. And I think that maybe with some guidance and the opportunity, taking the opportunity that's at hand with the new district attorney and specifically who it is, that there may be that wiggle room to present it that way with the dismissal up front. I think there was, some really good points made as to why that works better and it doesn't get complicated with the criminal courts later on. So I think I'm still processing it all, but there's definitely good information given about the benefits of having it dismissed up front.
Yeah. Well,
Can I ask a question? Are you all thinking about this for misdemeanors or felonies or both? Because I know, I totally agree with Judge Anderson. I mean, I don't think any judge would have a problem with the misdemeanors, but is this for both? Is that
that's the lower hanging fruit. I think at least to start, that's the place to go. The idea that people are sitting in competency restoration limbo on misdemeanors is just obscene. Yeah.
It's certainly counterproductive, if not obscene.
The more polite way of putting it.
Um, that's all good stuff. Judge Parsons, any change in your thinking as to, I know you expressed earlier on that you thought it would be nice to have that a little bit of extra motivation for folks, but any of these issues change the thinking on that for you?
I still think that for certain people, if you didn't have the complication of criminal courts kind of controlling your world, that could for some people be the only way they're going to comply, right?
Yeah. Yeah.
I think, but for sure, that is a concern of, one of the concerns was, okay, so A, the fire hose effect, and then B, okay, what does that mean practically speaking, right, in dealing with the criminal? Because, probate experience, at least in Harris County, is like Judge Prashner, we try to stay as far away as possible from the criminal courts, and they should do the same from us.
Yeah.
Because we tend to not mix well. And I don't know why that is, but I think it's like, civil lawyers and criminal lawyers, it's like reading Greek for each other. And so we don't understand each other at all in our languages. So I definitely see the complications that could arise, depending, of course, on the judge. And, so.
Right. Yeah.
It's a lot to consider. And I think rightly so for Judge Cox's hesitation to kind of get in that ball game yet.
Makes sense. So Judge Park, you've been taking all this in. I'm really curious to know what you're thinking as far as whether this seems like something we could ever make happen in Stark County.
Well, it's sort of interesting because I didn't know that Judge Stormer was resisting those cases from across the street where our felony court is. With regard to our forensic coordinator, we were trying to make our docket a little bit more robust. What's happened is our local state hospital is doing some renovations for the past year and a half, so they really don't have one that they're releasing to consider for AOT. But I did have some cases involving, substance abuse, some severe substance abuse, as well as a younger individual with severe psychiatric issues in terms of self-harming. And this has been a very helpful discussion to listen to, because I didn't know that there were the statutes in Nevada, Florida, and Texas, because we were working on an informal basis. The young person with the substance abuse issue, he's had it for a number of years. And we actually were exercising, I guess, co-jurisdiction, and he essentially violated his probation because he kept testing dirty. And I think we were just sort of waiting to see who was going to do what first. But eventually what happened was he got into I terminated the OPC so that he can go into an inpatient program, an intensive drug program. And then what they'll do is they'll alert me whenever he's ready to come back out to start the OPC process again. And for the other individual with the developmental disabilities, but the severe harming tendencies, she actually understood what was going on, is what we've concluded, because when she found out the charges were dropped, she just started acting out again. So, in terms of the cooperation between the courts, I think that can be achieved, because like I said before today, I didn't know that there were actually statutes in the other states. We're just sort of trying to help people the best that we can. So I really appreciate the input from today's discussion.
Yeah, great. And I'm sure the situation you're describing is very familiar to our veteran AOT judges on the call today, because it's inevitable that people who wind up in AOT are going to have criminal justice interactions during the period of their AOT, many of them. And so there's all kinds of issues that routinely come up. Does the AOT stay in effect while the person is in jail? Can we make sure that the treatment plan is still delivered while they're in jail? Can we make sure they're getting their meds? It's something we talk about a little bit in our white paper. But do you see, Judge Park, much hope that we could get your DA to consider actually bringing new people into AOT who are stuck on competency restoration now, and you know, on this kind of treadmill and potentially have an opportunity to have a better path?
Well, we actually have a new DA.
Yeah.
That was just
A lot of that
elected.
going around.
So I'm sure that he would, be willing to consider it.
Okay. If you want to set up a meeting, and I guess this is a next step that I would address generally. Anyone wants to, move forward with this idea in your county by having a meeting with your DA, I would love to be part of it. I'm sure Mark would like to be part of that as well, particularly in Ohio, but elsewhere as well. Because we feel like this is the next frontier for AOT. This is really the uncharted territory, and is just so much good that we think we could do with this model for people who we are not reaching now. Anyone else with any final thoughts on this subject? Okay. Well, that brings us pretty close to the end of our 90 minutes. Does anybody have any thing they would like to ask other judges about maybe things going on in your court that have been of concern to you lately that you'd like to get some feedback on? Just throwing the forum open for any of that. Okay. Apparently not. That's fine. Well, I actually am going to raise another issue in our remaining 10 minutes. Because this is actually something that's come up with in a lot of our TA work, because some situations that we've been told about by some folks who we have been, working with on the provider side to operate AOT programs have told us about some situations with interacting with their courts that I thought merited some discussion. And I'm just curious how people feel about this generally. Where you have a situation where it has become apparent to the court that AOT is simply not working in this particular case, where the court has kind of lost faith that the person, as in many states, is part of the criteria, right? Is someone who is likely to benefit from AOT, and therefore, because the court feels that person isn't likely to benefit from AOT, thinks that it might be worthwhile at that point, or even necessary to terminate the order early. I'm wondering how people feel about whether that is a decision the judge can and or should make unilaterally, or if that should be something that happens with a consensus with the treatment providers. Because, we know of lots of situations where people are not doing well on AOT initially, and this model can take some time to really take hold before something clicks for an individual. So do you, as a judge, I guess this is the question, feel like if you are convinced this is not working, do you feel like it's appropriate to unilaterally say we're going to terminate this order? Or do you feel that that's something that should not happen unless the treatment team is on board with it? That's my question.
I have a strong feeling about that. I think the judge should never just unilaterally make that decision. First of all, we're not trained mental health professionals. And over the course of years, we've learned that we're not always a good assessor of who's going to be successful in long-term treatment. So we don't know.
Yeah.
And you have to, I think generally speaking, as we go through just treating anybody, any participant in AOT, we have to defer to the mental health professionals for their assessment. Sometimes we observe that their opinion doesn't seem consistent with other things, and that's we have the power to question it and suggest they do something else. But generally, we're not the treatment providers, and we're not the day-to-day hands-on. So that's one. And the other one is you just never know. I was just explaining, had a meeting yesterday talking about it. One of our participants, it was his third or fourth time through AOT. And one day he came in court and just said, I get it. Everybody here is trying to help me. But it took all 2 years of being somewhat engaged and gradually more engaged before he had that epiphany. And then it was wonderful. You know, he became a role model for others.
Isn't that amazing?
I would second that, Brian, completely. I've been a judge long enough and dealt with enough people to know that, people I least expect it to do well, people I expect to do well don't, and everything in between. So, I bury my ego in that regard and don't take it personally. My goal is to try to, get that person the help so they're not coming back with more cases in the future.
Right.
It's interesting as you pose this. I got a letter yesterday from a client that I had dealt with in AOT from very early when we started doing it. He's now living in Indianapolis. He, of course, graduated out of our AOT, and we reunited him with family in Indiana. And he wrote me asking personal help about trying to get his property back and some stuff like that. I don't know that I could really help him, and I'm going to direct him to his lawyer. But that being said, he had some interesting things to say about his experience in the program and how much, he commented that the one thing that was big to him was how I, as a judge, had not played that game and had really been focused on his recovery.
Yeah.
And he was very grateful for that. And I have to tell you, that was a real, we don't get a lot of compliments for this stuff that we do. And it's a really nice compliment to hear that when it's not asked for, it's not invited, and yet somebody takes the time to write a handwritten letter to you about it. And that's special stuff. And that, I think we all as judges, I used to put what's called a shrine on the walls of my courtroom. And it was the nice cards or letters that attorneys, I've got a little coat rack that somebody made for me, while they were in treatment. And I used to put it all on my walls. And I still have it in my office now. You can't see it because I've got the background. But, that's really important because we don't always see the good work that we do because that person doesn't come back. They're not charged with another crime.
Right.
So it's real important to understand and to acknowledge that we have a lot of successes as we're doing this work, but we don't always see the success. We see the failures. So it's important to focus on the successes and the good work that we do.
Very true. Thank you for sharing that.
Brian, you're.
Yeah. Judge Parsons.
I'm.
Oh, Judge Parsons. I'm sorry.
Amy, go ahead.
No, I was just I agree. I mean, I think the unilateral decision is never a good idea because we as judges, we need to stay in our lane, and our lane is the law. Now I happen to also be a social worker, so I have to watch myself because I like to straddle the lanes, or that's my tendency. And I have to constantly tell myself to stay in my lane, which is not the social work part of it. However, I will say that, I think it's good for, Judge Anderson, you mentioned this, that, it's more of a collaborative, like questioning, like, okay, you've been doing this for a long time, right? You've seen your AOT patients come in and out and you have enough experience to kind of go, well, I don't know, maybe this person, isn't so great in comparison to what I've seen in the past and it may not work for that person or vice versa. We've had some cases recently where the court staff tends to feel that a person should stay longer and the provider docs have said, we think they're good and we don't need to extend them.
Yeah.
And so we would have conversations, will you talk to the doctor about that again, just to reevaluate that and maybe suggest and, have conversations about it. But no, I would never feel comfortable making that decision on my own for sure.
Right.
But I do think it's the court's role to maybe suggest or question, or at least maybe have more, something thought a little further, if there's an issue that's come up. So I think, it's kind of like, just because we're so new, and so our provider is new at doing this, and so learning to communicate with each other in a way that we understand each other's language, because again, doctors and lawyers and judges don't speak the same language.
Right. Right.
And, doctors and judges are used to being the king of their world. And so neither likes to be questions. And I think that having to really collaborate and listen to, the suggestions or thoughts, but the clinical side, the clinical piece, the clinical recommendation is what we as the court would use to decide in our ruling, right? So you can't have one without the other. So.
Sure. You put your finger on what makes this model tricky and always interesting. But Judge Prashner, do you want to add something?
I was really struck by what Judge Anderson said, and I completely agree with it. I mean, what's called for first for the judges in this is humility. I don't think we're by any stretch of the imagination the most important parts of this team. The most important parts are the actual providers. They schlep in front of us, we encourage them, admonish them a little maybe, but that's not the most important part of their week when they see us. And the only two people I've kicked out of our AOT program were both people that the care providers said were dangerous and they were scared to death to go see them. And as one of them put it, my life is worth more to me than this job. Our local mental health authority still has the obligation to provide care for them, but they don't have the right to be in the AOT program if, they're dangerous to the folks that I'm sending out there. But other than that, I don't have any problem being humble about this because I recognize what my limitations are and my lack of any qualification whatsoever in the relevant fields. And it's good to hear judges whom I instantly respect for saying this say that, I'm not God, I'm not the king, and I'm just here to play my role and that's it. I agree with that.
Well, for sure, I think the AOT programs live or die by the case managers who are doing the work out there, right? I mean, they're the ones that get that daily rapport, that get that, they do the hard work, and they're the ones that are, we just are there. I consider us to be like a support for them. The case manager will say, Judge Parsons, I really need you to reiterate this because I've been struggling with getting him to understand, or, getting him, this particular issue. Will you try to drive that home? And so, they're the ones making it happen. And I just consider myself to be the support of that. And hopefully it helps. Sometimes it does, sometimes it doesn't. So.
Yeah.
Very well put. And a great point to end on, unless anybody has any closing thoughts. I think we've hit the end of our 90 minutes. And I just want to thank everybody so much for taking time out of your busy day to participate in this. I think it's been super helpful. Hopefully it's going to actually lead to us moving forward on this idea that we and Mark share, that we got to make the folks in competency restoration limbo our next audience for AOT. And I'm sure this is going to be very useful to the people who watch this recorded. And I wanted to really thank you all so much for being here, and we'll do this again in 4 months. And of course, in the meantime, stay in touch with us at all times. We'd love to facilitate any communications between judges any day of the week. So
thank you.
thanks,
Very
everyone.
helpful.
Thank
All right.
you very much.
Letting me
Take care.
join you all.